And thank you so much for staying with us here on Morning Live on this Friday morning. Let us get you the top story for this hour. The Supreme Court of Appeal in Bloemfontein will hear arguments on the legality of euthanasia or assisted suicide. The Minister of Justice is appealing a North Gauteng High Court ruling. In April last year, Judge Hans Fabricius gave 65-year-old Cape Town advocate Robin Stransham-Ford permission to be assisted by a medical doctor in ending his life. He died before the landmark ruling. The Department of Justice and Correctional Services says that although the judge ruled that his judgment was case-dependent and not precedent-setting, it has far-reaching implications and is open to abuse. For more on the story, we cross live to Bloemfontein. That is where our reporter Palesa Moeti will be speaking to the Justice Department spokesperson Mthunzi Mhaga. It's over to you, Palesa.
Good morning, Palesa. Indeed, as you put it, last year the High Court in Gauteng made a precedent-setting decision where the judge ruled that a physician should be allowed to administer lethal doses of medication to his patient who was at the time terminally ill. Now, unfortunately, as you said it, the patient died before the medication could be administered, or rather before even that ruling was made. Now, joining us right now is the spokesperson for the Department of Justice and Correctional Services, Mthunzi Mhaga, who's just going to take us through what this case is really about and who exactly are the role players involved. Mthunzi, thank you for joining us. And just take us through who the role players are.
The appellants are the Minister of Justice and Correctional Services, Minister of Health, the National Director of Public Prosecutions, as well as the Health Professions Council of South Africa.
Now, take us through what exactly is expected today. You know, the deliberations. What should we expect from these deliberations?
The Minister of Justice and Correctional Services, together with the other appellants, have a difficulty with accepting the judgment, which is a precedent setting of the North Gauteng High Court, in the sense that it allows a medical doctor to end the life of a patient. And that has a bearing on the constitutionally entrenched right to life, which is sacrosanct, and the bearing on the right of or powers of the National Director of Public Prosecutions to prosecute those that would have been charged or convicted or charged, yes, of ending the life of a person. Because remember, that is a criminal offense in our criminal law, and as such those powers have been taken away because the judge ordered that those medical practitioner or that medical practitioner would be absolved from prosecution. And from an ethical point of view, the Health Professions Council of South Africa has an issue with the fact that the oath of office that a doctor takes is to preserve and save life, not to end life. So the judgment in itself has a bearing on the Constitution and the rights that are enshrined therein. And therefore, a higher court with 5 judges must make a pronouncement on such an important matter, which has far-reaching implications. And the problem that we also have is that in as much as the judge said it's case-dependent, it has since opened an uncontrolled free-flow window where other applicants or other patients would use this judgment as a precedent to make other applications. And therefore, in as much as you confined it to one case, but the implications are far-reaching.
Have we seen any other cases? You said that it has opened a window for other applications, but since that particular case last year, have we seen others coming forward?
I'm not aware of any other applications that have been made, but of importance is the fact that the judicial precedence tells you that any other patient would use this case as a benchmark or as a reference in making that application, and that cannot be prevented. And we're saying those are the far-reaching implications that it has, because the sacrosanct right to life is in the Constitution, in as much as we acknowledge the right to dignity as well, but that should not actually be a selective approach to say that's the only right that overrides the other, because right to life is sacrosanct, and whoever ends the life of a human being is committing a crime of murder. And in this instance, we're saying this higher court than the one that made the judgment should pronounce itself on the matter because of the far-reaching implications that I've just narrated earlier on.
Okay, now just lastly, obviously I would like to think that whatever decision the court would ultimately take would have a bearing on legislation which would then be written.
I think for now, let's focus on ventilating the issues that relate to the judgment. The issue of decriminalizing it or legislating same will come in depending on the outcome of the judgment today. But we are confident that that judgment would be found to be wrong, and as such will be overturned.
Thank you very much, Mthunzi. That is the spokesperson for the Department of Justice and Correctional Services, Mthunzi Mhaga. A full bench of judges is expected to hear submissions from the various parties from around 9:45 this morning. With that, it's back to you in the studio.